This full-page article is in the New York Times today. It's talking about Weinstein's trials coming up, and it refers to B. Montague, Roland B. Montague, and another guy in the third picture. We all know him. That's Bill Cosby there, and the full-page article, New York Times today. Now, they're talking about the trial for Weinstein that's going to be coming up. And one of the big problems in the trial, well, first of all, he faces two women that are bringing charges. One of them said he forced her to give him oral sex in 2004, and the other one said he raped her in 2013. And those are the two cases that seem to be in the, I guess, in the indictment, but actually the attorney's office, they would like to bring all these other women in to show a pattern of sexual behavior of his, and they'd like to bring a lot more women in to the case to testify, even though some of those have a statute of limitations or they didn't bring charges or whatever, just to show the jury that most likely he committed the sex acts on these two in 04 and 13, because all these other women will testify as to what he did to them or tried to do to them. And this gets very complicated, frankly. In fact, it's complicated in the paper. Now, this guy here in this picture, Roland B. Montague, he's sort of famous. He set the line of cases because he was a chemist, and this goes back to 2000. He sent an Emerson bromo seltzer bottle full of cyanide to the director of the Knickerbocker Athletic Club, with whom he had an argument. A woman living with the club director took the fake medicine for a headache and died. And that case has been on the books for about 80 years, and he's famous in New York because of this case. Now, at the trial, the prosecutors presented evidence that Mr. Molyneux had previously poisoned a rival for his fiance's attention in the same manner with a mailed till of poison masquerading as medicine, though he was never charged with the crime. So basically, that's how his case came down. One woman was dead, and the other one had poison mailed to her, but he wasn't charged with that. A year later, the Court of Appeals overturned the conviction in a landmark decision that said the state could not present evidence about other alleged crimes because jurors would believe a defendant was guilty of the crime charged because he committed other similar crimes in the past.
Wow.
And that's one thing about Bill Cosby's case. He had, I think the first case he had was a mistrial. Then the second case, he was found guilty, but they brought in this prior bad acts. They start bringing in all these other people that said Cosby tried these different things with them. And because of that, I think they convicted Cosby in that second trial. The first time he got a mistrial. Then when they're talking about these things, about what you do in these other cases and how they can be talked about in your trial now. Like if I'm on trial now, can they start talking about all these things I did in the past? Some of them are, a lot of them are statute of limitations is right on them and everything else. Now, one thing this Molyneux, he started going through, they start talking about laying out 5 exceptions. The judge could commit evidence to establish motive for the crime or to prove the crime wasn't an innocent mistake or to establish a common plan. So they could use some of these other sexual acts to show that evidence, and then the jury could take it the way they wanted it. It's funny that the jury in this Molyneux, second jury in this Molyneux, he's from 1900. That would make him about 80 years. On that second jury, he walked. He was a chemist. Now, the Weinstein case has similar things involved in it, but one thing about Weinstein, Congress recognized convictions are often hard to obtain in sexual cases, in which there are seldom witnesses other than the victim. That means if the woman says, he tried to do this, he tried to do that, I say, no, I didn't, it was all consensual, then that's a tough case because it's who the jury's going to believe.
Right.
Some of the cases, the federal rules of evidence were changed in 16 states, including California and Connecticut, in which there are seldom witnesses other than the victim charged. The federal rules of evidence to permit evidence of accusations of similar assaults. So in all those states, you could put in accusations of similar items that he did. Even though he wasn't charged, they all took place in the past. But if a man fought with a girl trying to rape her and different things and didn't get it done, I mean, it would be, then you can show he had these other couple girls in different situations and he tried the same thing. So then the jury will figure, well, if he did it those other times, he probably did it here and we're going to find him guilty.
Right.
Now, so that's a big deal in this Weinstein case, which is what this whole article is about. One, because there were a lot of other girls supposedly that have come forward now saying he did this and that over the years and I wanted a job and all these other things, and they want to come forward and they want to testify about things he did even though he was never charged, because they were dropped the charges, they were afraid to come forward. Now, and a lot of the things against him are incidents where he had a long history of luring young women, many of them actresses, to hotel rooms with a promise to talk about a work opportunity like a script or a role, then sexually assaulting them. Now, in the 2 cases that are going on, in 2004, a woman said that he forced her to give him oral sex. And then there's another case in 2010 that they interviewed Paz de la Huerta, an actress who told the Vanity Fair magazine that Mr. Weinstein overpowered her and raped her twice at her apartment in 2010. But that's not in the charges here, it's just going back over his history. Now the one in 2004, this Lucy Evans, former actress, supposedly he forced her to give him oral sex. And an identified woman, they wouldn't give her name, said he raped her at the Doubletree Hotel on Lexington Avenue in 2013. Now those cases are in this trial. So the whole question, and what his lawyer and him and the prosecutor, they're all fighting about, can they mention these other cases from years before, where they have all these women now will come forward and testify about things that he did or tried to do to them. So this is going to be interesting, and it's going to be up to the judge sitting there to decide which one of those previous acts, or how many of those previous acts, he'll let come forward. Now this was in the paper today, New York Times, so I think the play has just started. Thank you.